What makes it so attractive people from certain countries which are facing backlogs like India and China?
That are beyond just the traditional method of winning an H-1B lottery.
Okay, what can I do now so I can de-risk myself from the whole H-1B?
There's also a lot of dilution because there's EB2 NIW, there is EB2 PERM.
USCIS is probably getting a lot of bad, low quality applications.
Right? But when you only have 3 weeks and maybe an officer has 20 applications to review within a given timeline, it's tough.
You may not be able to convince an officer, as well as a third party neutral attorney that participates will be able to do it.
That H-1B cap exempt role. So the moment that you lose that 5 to 10 hour job, then that concurrent approval for JP Morgan in that scenario is also dead in the water, so to speak.
Hi, Nicole. Welcome to the Smart Immigrant podcast. It's great to have you here on the show. I know we've worked together on a couple of cases, but I'm glad that you're on the show and we can go over a lot of things. I'm really excited for this conversation. But before we begin, for people who don't know about the firm Manifest Law, or people who do not know about you, can you just give us a good, probably 5-minute introduction about like what you specialize in, what you do, things like that, your background?
Sure, absolutely. So my name is Nicole Ganara. I am the co-managing attorney here at Manifest Law. A lot of my work has to do with helping young professionals and just professionals generally with working, residing, remaining, and being in the United States in as stable of a situation as possible. I also like to call myself almost like a beast tamer of the beast known as US immigration law, right? I really do my best to come up with really creative solutions for a lot of individuals who really struggle with navigating this arduous process, right? In terms of Manifest Law, I think what we really pride ourselves in is taking a very human-centric and solutions-oriented approach when it comes to helping individuals and supporting individuals in their immigration journey. I really think that what we prioritize and what we essentially have a little bit of expertise in, so to speak, is in compiling really great EB1A and EB2 NIW applications. But of course, we have a very strong background in a whole host of immigration pathways, everything from business immigration, like non-immigrant visas, to talent visas, to some of the more, I guess, nuanced or specialized applications that could be out there.
You brought up very interesting points here. You brought up the whole struggle aspect, which I definitely want to get into, because it's one thing to be an immigrant and kind of be going through it, but it's also another thing to have the perspective from the standpoint of an attorney as to like what are the different struggles that your clients face, which obviously you help alleviate it as a legal professional. But can you just dive a little deeper into exactly what do you mean by struggles, right? And different people have different sorts of struggles, but can you just point a few out so we can know what we're talking about here?
Yeah, so I'll tell you some of like the couple common scenarios that I see that I interpret to be like a struggle. For example, we get a lot of individuals who come to us quite early, people who are about to graduate or are in the middle of their first year of OPT over like a 3-year timeline for STEM OPT, for example. And a lot of the times their struggle is, Nicole, I'm very concerned about my ability to stay here. I've enrolled into the H-1B lottery, and I feel like there's not really any hope in terms of succeeding in winning this lottery, right? That's a very common example of what I call a struggle, because they really need a lot of guidance and direction on maybe alternative pathways that are beyond just the traditional method of winning an H-1B lottery, right? And a lot of our work, especially in the consultation phase, is giving those right tool sets, tips, and resources to give them a backup plan beyond just the H-1B lottery. Another very common case type of like a person who's in the middle of a struggle is someone who's already even in an H-1B, right? They've already won. They're in the middle of their professional careers. They've already gotten an EB2 perm or an EB3 perm process completed with an approved I-140, but they feel like they're in this endless and vicious cycle of waiting for the visa bulletin to come current when it could possibly never become current based on some of the existing models that are out there that are calculating like the improved statistics and everything. In those scenarios, it's about really starting what I call a portfolio building process, or giving them the right direction, so to speak, to make sure that they are going to be in the best position to apply for something that's within their control, like an EB1A, or even for some individuals who are currently in the EB3 kind of category, building towards a solid EB2 NIW case.
There's a ton of, I mean, the H1B is so oversubscribed these days, over the past several years, that there are way more people not getting it than people getting it, which is a very absurd trend if you even ask someone probably from 10, 12 years ago, right? So I'm just
Mhm.
wondering, so there are these students who say, hey, I didn't get the H1B, or maybe they are already a student and they are like, okay, what can I do now so I can de-risk myself from the whole H1B and then eventually the whole endless wait, because there is no light at the end of the tunnel going down that path. What would your advice be to early stage students that reach out to you saying, hey, I have all the time in the world right now, but I don't know what to do? What do I do?
All right, so I actually have a few tips on this, which is sometimes a good way to circumvent some of the issues related to H-1B is to focus on potential cap exempt jobs. I think a little known loophole that some people don't realize is that you could acquire a part-time cap exempt H-1B and then concurrently file an H-1B for a private employer. So just to give you an example, you could get a 5 to 10 hour a week job supporting a professor in a research project as like a research assistant, right? And then concurrently file a 40-hour a week job for a company like JP Morgan, right? So a lot of people don't realize that you can hook on a private employer to a cap exempt application, right? So that gives you more control for yourself, because cap exempt employers don't really require there's no lottery process. So there's no odds. It's just finding that right role. Now, alternative to that, I think what a lot of practitioners may have missed is that the government quietly updated some of their FAQs related to the H-1B. And there is a possibility, and depending on how you structure it, for you to even self-sponsor, quote unquote, an H-1B through developing your own startup. For a lot of individuals who are engineers or creative professionals, or really individuals who have entrepreneurial pursuits, right? If you structure a business in the right way, there is a way for you to enroll yourself into an H-1B, or separately from that, if you create your own nonprofit research organization, self-sponsor for a cap exempt organization application, right? So I really do think that there are some alternative pathways, but I will also say very quickly that the earlier you start portfolio building for a green card case, such as an EB1, right, the more likely you would be able to achieve an O1 for yourself. Because if you take a look at the criteria for an O1 and align it with the EB1, they're substantially similar. So if you are already at a space to even meet the 3 criteria for an EB1, chances are you'll be able to get an O1. So that's usually what I advise a lot of students, especially when they come to me early, which is that the earlier you start portfolio building towards an EB1, the more likely you can find an intermediary status like an O1, for example. And when it comes to the H-1B, there's a lot of creative ways to acquire one and to fulfill your immediate and short-term needs, to buy yourself or build yourself a runway, right? So that you can develop towards a green card case in the United States.
You mentioned that someone can get a cap exempt, probably a 5-hour job with their cap exempt employer. In this case, probably a university research professor, of or the likes. And then, are you saying that the same person can tack on, like you gave the example of JP Morgan Chase, but like a 40-hour job concurrently filed, and that concurrent filing doesn't need to go through the lottery? Is that what it is?
That is correct. That
Even
is
if it
correct.
is,
Now, here's
wow, okay, this is something that most people don't know.
Yeah, so I know a lot of people don't know that, but I think the biggest risk element, just to be very honest with everyone here, is that you must maintain that H-1B cap exempt role. So the moment that you lose that 5 to 10 hour job, then that concurrent approval for JP Morgan in that scenario is also dead in the water, so to speak, right? So I will say that right now there has been significant interest by even multinational companies to set up their own nonprofit research organizations to house all those candidates that can't win the H-1B lottery in order to effectively file these concurrent employment applications, right? So some really smart companies out there are really actively considering it as like a safe harbor when their candidates don't win the H-1B
And there
lottery.
is obviously, from the name, there is no limit to the cap exempt, and it's pretty immediate. You don't need to wait for the season to arrive, every March and
Correct.
stuff. Yeah.
Absolutely. Yeah. So I think that, again, it's something that a lot of practitioners do miss. I will say that as each kind of month or even week passes by, more and more people are discovering that this is something that can be done. And there are maybe several services out there that can provide you leads or the opportunities to get some of these part time university roles. But that's where I would chime in and say, if you come to someone like me early as an attorney, right? If you're in your junior year of college or even your senior year, I actively encourage people to be close to their professors, get in touch with them, network with them to get these like part-time opportunities that can build them towards success in getting an H-1B approved for a private employer.
Got it. Yeah, I mean, I definitely, this is probably a topic for another whole new podcast episode, because this is the workarounds that are legally possible are very, very student centric, and it's very important to know as well. And to make an informed decision whether or not you choose to go that path, that's a different story, but at least to make an informed decision. Now, you mentioned about the EB1A and the EB2 NIW. A lot of people
Right.
have a lot of confusion. We get repeated questions all the time about, hey, is an NIW good for me, or is an EB1A good for me? How do I pick and choose? What are the qualifying conditions, let's say, where it's not like qualifying for the EB1A or NIW? That's pretty transparent out there on USCIS website. But for my scenario, how do I decide which one to go with?
I think it actually depends on where you are in your immigration journey, right? I find that the EB2 NIW is less helpful for individuals who don't have the luxury of time and are not currently, let's say, in an H-1B status, right? So, for example, if you're on an H-1B working for a company like Meta, the EB2 NIW might prove to be fruitful for you, even if you have an EB2 perm process already completed, primarily because you have control over your own destiny, right? So if you decided to leave Meta in that scenario and move to a company like Amazon, you're no longer pressed or really feeling the pressure of getting a new perm process done, right? Another thing that I've seen, especially given I have a strong background in advising multinational companies, so I'm very aware of what they're looking for in their HR departments when it comes to elevating applications for recruitment or for acquisition, so to speak, right? I will tell you that it looks positively in the job market, especially in your application, if you have an EB2 NIW approved, because then the company thinks to themselves, I don't need to pay for another perm process for this individual. Because if you do a self petition EB2 NIW, regardless of what organization you are working for, it stays with you with no requirement to redo a perm. I don't think an EB2 NIW is helpful though for individuals who maybe are in their last few years of OPT, let's say, primarily because of the wait times that are associated with the EB2 NIW. So individuals who are in the all others category, it might still be helpful because the wait times are about 14 to 16 months, right? So it's not too bad. But really for individuals who are born in China or born in India, it's less helpful. I will say, of course, case by case basis. Sometimes for individuals who are in the middle of a portfolio building process with an EB1, but they have a very solid case for an EB2 NIW, I will tell them there's a benefit to getting an EB2 NIW approved. Why? Because you could set a priority date for yourself. So if you don't already have an approved I-140 in any other context, then setting a priority date through an EB2 NIW can be quite powerful. As you and I both know, Simon, even weeks difference when it comes to those cutoff dates can make or break someone's case in the future or their timing for their application.
Yeah, it sometimes feels like USCIS is literally teasing a lot of people because they take it so close. We have clients where it literally came to the previous month and then it went back like 5 years. It's just
Yeah.
crazy. Now,
Yeah, and I feel for a lot of those clients because sometimes it could be even a matter of days. You know, the cutoff date for a while was like February 1st for a lot of people, right? And you have people who have February 3rd priority dates, right? You're 2 days off,
yep.
two
Yep.
days off.
And one of the, just to summarize the use cases or the benefits of the EB2 NIW, number one, if you are, let's say, in the fifth or sixth year of your H1B and you don't have an approved 140 yet, then you cannot renew your H1B indefinitely. So and let's say your employer for whatever reason is not willing to take that step, and even if they were to take that step, the whole perm process itself probably might take a year, and then they need
Correct.
to go for the 140 by the time you're done on your H1B, and then you can't renew it. So that's one use case where you can self petition EB to NIW and then continuously approve or renew your H1B. And I think the EB to NIW premium processing, 140 premium processing is like 45 days or something. So that's more in the real.
Yeah, it's 40. Yeah, it's 45 business days. It's definitely a healthier timeline, let's say, compared to the EB1A
Correct.
premium processing
Yeah.
time.
So that's one use case. And this other use
Mhm.
case that I'm summarizing here for EB to NIW is if you don't have a priority date at all, then it helps you secure like a very early priority date. And then maybe you can put in additional work into your profile building, get to the EB1A qualifications, and then like file for the EB1A. That way you can use the
Correct.
EB2 NIW priority date towards your.
Absolutely. I've seen a lot of people do that. We've definitely been engaged for what I call concurrent or subsequent applications, where we'll like help advise someone in slowly building their EB1 case, getting those letters and references done. But in the meantime, quickly file an EB2 NIW, get that priority date secured so that they have peace of mind that they have something early on, so to speak.
Yeah. Now,
Mhm.
coming to the main part, the EB1A. What makes it a crown jewel in the whole set of things that people from certain countries which are facing backlogs like India and China, what makes it so attractive that a lot of people are flocking towards this?
Frankly, it has to do 100% with the wait
Mhm.
times, right? I think that when you take a look at the visa bulletin, even like over a period of time, and even in during the healthiest periods of immigration in the United States from several years ago, you can tell that the EB1 generally doesn't have the strong impacts on wait times compared to, say, EB2 or EB3. EB2 and EB3 generally get heavily flooded very quickly with the perm processes. There's also a lot of dilution because there's EB2 NIW, there is EB2 perm, right? So there's just a lot of applications. With EB1, there's really only three types: EB1A, EB1B, and EB1C, right? It's not as heavily diluted because it's very, very hard to get an EB1B, which is outstanding professors. You need to have, or such researchers, you need to have the right employer be willing to sponsor you. Same thing with EB1C. You need to have the right structure and an employer to sponsor you. So generally speaking, they're less likely to get impacted by a flood of applications, so to speak, that would impact any wait times on the visa bulletin. The other thing too is that I have found, and this is very much an anecdotal argument. I can't really tell you if I can prove it other than from experience, right? Is that EB1A is almost more future-proofed compared to EB2 and maybe even EB3, right? So regardless of whoever is in power right? For example, in administration wise, there is a keen interest on both sides of the aisle here in the United States to keep individuals of extraordinary ability in the US. In my experience in many different administrations, you are less likely to be impacted by these different administrations if you're walking down the EB1 pathway compared to the others. Because take, for example, EB2NIW. It wasn't until mid 2022 when the Biden administration really expanded national interest waivers to the wider like STEM field that people could benefit really from that process. It used to be a lot harder to get an NIW approved, but I personally have some concern that that could be specific to that administration or an administration that is closely aligned. It's unclear, for example, how the Trump administration could feel about the EB2 NIW moving forward, especially with such a strong demand for that particular category. However, you realize there's not a lot of chatter about EB1 cases, right, on both sides of the aisle. I think it's because there's a general consensus between Democrats, Republicans, and whatever parties that are out there that we would want the best of the best to be here in the United States.
So EB1 or talent visas like O1A, EB1A, etc., is uh, largely a bipartisan agreement at this point, is how it's looking like.
Yeah, that's my general feeling. Like, especially having been involved in immigration throughout those different kind of administrations, I really don't see how maybe a Republican-backed agenda, which is generally anti-immigration, would have any really strong concerns about the EB1 program or these O1 application type visas.
I know this will come across as music to a lot of people's ears because there isn't a week that passes by without someone who is either interested in going through our journey or who is already in our journey and like wants to file and stuff like that, right? There's not
Right.
a single week that goes by where we aren't asked the question, hey, what if Trump wins this election, right? Like, how do you see things changing from an EB1 standpoint and all that? And personally speaking, I think I've shared this way too many times now. I got my EB1A when Trump was president. The only difference that was there, though, was he stopped waiving interviews for employment based candidates. And I had to
Right.
last minute like get this interview notice that hey, come in for an interview. And then I realized that this has been going on since like 3 months up to that point, where they've completely stopped waiving interviews. Apart from the added timeline that apart from this few months that added to my entire journey, I didn't see how like the adjudication was way too different. Or of course, people are talking about the adjudication standards for EB1A rising over the years. What have you seen, Nicole? Like, what's the trend that's going on now? um yeah.
I think it's definitely been getting tighter, but I don't necessarily believe it's based on any administration perspectives. I think it has to do with just the influx of individuals that are seeking the application who are submitting bad cases, right? When it comes to like the recent concerns or like rising of like scrutiny, so to speak, or standards for the EB1, I would say that it's less pushed by maybe the administration and probably more so pushed by the influx of applications that are coming in, along with probably some bad applications that are really being filed for the EB1. Some people are very desperate and there's really no other choice, and they'll file with what they have. Right? Now, what I will say is that with this influx of applications, the government will see a lot of commonalities, right? Some people believe a winning formula that existed in 2021 or 2022 will work for their case in 2023 or 2024. But when too many people start using this winning formula, it lets the government feel or makes them feel that, hey, why is it so common now? Why is everybody doing the same thing? So to take for you a very, very good example is the tightening of the association's argument when it comes to an EB1 application. So in the past, while certain fellowships like ACM and BCS could have probably qualified for that particular criterion, the government has come back and really pushed us hard and said, hey, why is everybody getting approved for these BCS fellowships? Is it truly an association that requires outstanding achievements? There was a pretty, I would say, damaging determination in August 20th of 2024 by the AAO. Don't get me wrong, it's not a precedental decision, it's non-precedent, where they basically just said, hey, BCS fellowship is really not that amazing because we don't have a solid understanding of who gets to determine or what determines you getting a BCS fellowship, right? So these changes to the membership criteria, I wouldn't say is because, hey, the government is thinking to themselves the standard is higher. I think it's that now it's getting too common. What gives? Why is it that everybody's able to qualify for this particular fellowship? So if I could point people in the right direction, I would actually encourage them to kind of take a look at more regional associations, focus on associations in your home country, focus on associations in other parts of the world that are not in the Western, I guess, concept of the world here, and focus on those which are less common, right, than what everybody has, so to speak.
It's very weird because on one hand you want people to be aware of the EB1A path because it's so relieving to a lot of people to even be aware of it and like put in the legitimate work needed to qualify for an EB1A. But a lot of people take it the wrong way as well. And then when people start posting on LinkedIn or other places as to like, hey, I had this and this and this is your 5-step formula, like just finish this off and like you'll get your EB1A, then people start making it a routine and they start doing a lot of these same things, which even if they had value legitimately, the organization sort of starts losing value when people start copying it and doing it again and again. And it's weird because then it's like it's a wrong approach. You're
Yeah.
just copying someone else's work at that point, which is not good. And you also mentioned USCIS is probably getting a lot of bad low quality applications. Can you shed some light on what are the things that you would classify as bad, right? Like what are low quality?
Right. So low quality applications to me are people who barely meet the three categories, right? Because I think all of us here are aware of the concept of final merits determination, where the officer takes a step back, they take a look at your profile holistically, and they make a qualitative assessment. They basically make a judgment call of truly, madly, deeply, are you the cream of the crop, right? So if, for example, for lead and critical role, you have one position at a company that you've only been there for a month, that qualifies. For scholarly articles, you only have one publication in a low impact journal, zero citations. And then your third criteria, let's say, was the press category, but it was sponsored content and it was very, very clear that it was sponsored content, then that to me is a bad application. Of course, technically speaking, you can make the argument that you've met the three categories that are required to move you to that second step of review, right? But it doesn't mean you're going to pass the final merits determination. I think there's a lot of people out there who file without an attorney or without the proper guidance, and they feel like, oh, if I can meet the three categories, then definitely I'm at the top of my application or the top of my field, right? So in that particular perspective, that's what I define to be a bad application. Or alternatively, there's a lot of applications that just don't substantiate a lot of the arguments that are being made. You can have someone who's actually quite well qualified for an EB1, but they don't feel the need for whatever reason to collect letters of recommendation to affirm some of the things that they're asserting, or they don't feel the need to really say or provide documentation to corroborate some of the original contributions that they have made to their field and why it's considered significant, right? So that's what I mean by a bad application. Either they're not well prepared, or quite frankly, they just barely meet the criteria. And knowing where we are today when it comes to the EB1 kind of criteria and what the officers are looking for, it's just not good enough. And I will say it sets a really bad tone for the officer who's sitting there reviewing the application. Because don't get me wrong, they're supposed to see every single application on their own merits and have it unique. But at the end of the day, a lot of officers have a lot of power, a lot of discretion to make a judgment call. And you have a bad tone that day or a bad sense of the applications coming in, it can really permeate even into your own application that was well presented and well done.
So in a way or the other, it's a pretty much a popularity contest
Yeah.
throughout your application. And how much do you make the officer fall in love with you from a profile richness standpoint, with true conviction?
And I will tell you, that's why I tell every single one of my clients that just as equally important as the criterion is the importance of your personal narrative that you're sharing with that officer, right? Why are you trying for the EB1A? Why are you how are you trying to convince this particular officer of you as a person to be granted this, what is essentially a very accelerated pathway to a green card, right? So what I mean by importance of a personal narrative is really writing down or really explaining to an officer in written word why you deserve this, right? So going back to what I said earlier, the X factor concept is so critical nowadays to a very healthy EB1 context, right? To an EB1 application, right? Anything that differentiates yourself, right, to an officer is going to be a really good anchor to your application. And as a little bit of a pro tip, I've seen a really healthy pattern of individuals who take the time to devote themselves to humanitarian causes that are associated with their field, usually have a really good narrative to share, right? So to give you an example, for the traditional engineer in the STEM field, right? If you go out there, you become a board member for a nonprofit organization that's devoted to helping children learn about the STEM field or learn programming. That's like an A+ argument for a good narrative, right? So not only are you at the top of your field, right? You're also innovating and also developing the next generation of professionals to the United States, which leads the officer to believe, hey, this is a good guy who's going to bring some benefit here to the US. And also the fact that he's a board member or he established this quite medium to highly successful nonprofit organization, clearly he must have stature in the field, right? And that's the thing people like tend to forget is that when you're on the H1B, of course you're not allowed to work for other employers, but you are allowed to volunteer your time for charitable causes and organizations without violating your H1B. So I always encourage people to take that route because usually nonprofit organizations or those charitable organizations are more likely than not to want to support you in your immigration journey or even write letters that could be very helpful for your application.
So when people are in this popularity contest,
Mhm.
aka their EB1A case, some of these cases can get pretty long, right? Like they can
Yeah.
run in 4 digit, like probably thousands of pages and stuff. How much do you think these officers even read the whole thing? Or is it practical to assume that the person will read the whole thing?
I don't think it's practical to assume that the officer will read the whole thing, right? Like even if you take it from a numbers perspective and you review like how many applications are going in versus the number of officers, I just don't think it's feasible, especially with the 15 business day premium processing timeline. Right. So with the EB2NIW, where there's a 45 business day timeline, there's an argument to be said that they would have a chance. Right. But when you only have 3 weeks and maybe an officer has 20 applications to review within a given timeline, it's tough, right? Obviously, I can't prove this one way or another, but what I can say is that I will find it hard to believe that they would review every single page of evidence that's been submitted for the administrative record for this particular application. So what is critical to a really good application, and really one way to test like an attorney, is how succinct and convincing the cover letter is. So if the cover letter is like 200 pages, right? Or like even 100 pages, it's like, what is the officer going to be able to derive from this in such a short amount of time, right? So a really, really good attorney cover letter or any cover letter for an EB1 should clearly and very easily outline why you qualify. Here are at minimum the 3 or 4 prongs that you believe have met. Here's clearly why I meet these things. And then that written and maybe this is like a personal touch that I have, that written argument for the final merits determination, which is also your personal narrative, right? That is really what I think they're reading, plus maybe some of the recommendation letters, and just checking that you did provide the proofs. So, for example, if you decided to argue peer review for judging, right? I think they want to see that you have the peer review certificates, for example.
What's some of the weirdest RFEs that you've seen in your career when it comes to immigrant?
Honestly, wrong name or wrong person RFEs. Basically,
Really?
yeah, I have seen RFEs in my lifetime where they mixed somebody up with a completely different individual, right? Or somebody of the same name, different company, different background, right? And that required a correction. So, thankfully, this individual filed with premium processing, which gives us access. Back then, there was like a hotline that we could easily call, and nowadays it's like an email. But we could send an email and say, "Hey, like this seems very erroneous, right? Like this person didn't work for Microsoft. I have no idea what you're talking about, right?" I will tell you that in a situation like that, chances are you're still getting an RFE, but the government will double back and be like, "Oh, sorry, here's the corrected RFE for the right
Ah,
person." Right, because they don't want to acknowledge such a strong issue to the point where it'll lead you to a direct like approval. Instead they'll say, "Oh, we sent you like the wrong document."
I
Right, so
see.
I've definitely seen that, and it costs people time and money, quite frankly, right? Because for you to pay an attorney to kind of intervene on your behalf, to talk to USCIS, to tell them like, "Hey, you've got the wrong guy," that's just a waste of time. But it does happen, and I've seen it happen.
Yeah, and at the end, it's the client that's on the hook for everything, that happens here, unfortunately, as well.
Absolutely. And
Yeah.
another weird RFE, and I think you and I both know original contributions can be a very tough category, but I have seen an RFE for someone who had one of like the most impactful patents in the semiconductor industry that was cited by like tens of like the biggest Fortune 500 companies in that space, get an RFE that says, well, the patent was for that single employer. We don't understand the major significance in the field, right? And when I'm telling you that this was a patent that was cited by Samsung, Mitsubishi, Toshiba, some of like the biggest players in the game, it's very, very hard for me to understand why the government would be wanting to push back on something that was so significant. But I digress. Like to me, it's a ridiculous notion, but I've seen a lot of crazy RFEs out there.
Do you see it as a point of concern that some of these cases, some of these RFEs are kind of like time buying RFEs? Have you seen those as well come out of it?
Honestly, I have. It's like kitchen sink RFEs that don't specifically address like your evidence. Like they might add like bullet points being like, you have a letter from this guy, but they're not making any specifics. I truly believe that these are time buying tactics, right? And I know that the government will say historically, the liaison meetings, the announcements, they will never acknowledge this. They'll say, no, we never do that, right? But I find it really hard to believe. And if you have a premium processing timeline of 15 business days, right, with the sheer amount of applications compared to the number of USCIS officers that are processing these cases, the officer doesn't really have another choice, right? They can't directly approve a bad case because it sets a bad tone, right? Or I can't speak to exactly like what their audit processes are, but I can imagine that if they approve or directly approve a bad case, that they're going to hear it from their supervisor or someone out there,
Mhm.
right? But the only other option in a premium processing timeline is to issue an RFE, right? So I can't help but think, just from a logical and very rational standpoint, that truly they must be doing something that is buying them time, which is issuing that kitchen sink RFE without any specific references to the evidence.
Yeah, and it's kind of also a point of concern that I don't think most of these officers understand completely the technical details behind a very, very high profile case
Right.
or a very capable client, that they end up just assuming things based on their level of interpreting what an extraordinary role they have played. And that's like a total mismatch of adjudication capability, because you present something like so strong that it just goes on top of their heads.
Yeah, I get where you're coming from, and I to some degree I will agree, right? I really think that where that can be changed or adjusted, and where I think it's actually more helpful to people who are interested in the EB1 is finding the right attorney or team that's able to digest those highly technical concepts that are about your role and write it and explain it to an officer in a way that's easily accessible. That is a skill set of its own, right? So, for example, like I don't consider myself to be a subject matter expert by any means in artificial intelligence, which is a very hot topic. But what I do pride myself in is being able to synthesize and summarize some very high level concepts associated with that field in a way that would allow most officers to understand it, right? If you've ever heard of the Reddit community ELI5, explain like I'm five, that's exactly what an attorney has to do, is explain whatever it is that you are doing as if you're explaining it to a 5-year-old, right? Because if a 5-year-old can understand it, then clearly a USCIS officer will be able to understand it.
And that kind of clarifies why, even if people have the urge to self petition, it is way more advisable to go with an attorney, because you're biased about your own extraordinary abilities, and even the language that you might use because of the years of conditioning that you've had in your field, that you may not be able to convince an officer, as well as a third party neutral attorney that participates will be able to do it.
Absolutely. And I will say, like, even from experience, not every single attorney is going to be very neutral, but that's why I always tell every single person, even if they're not my client, choosing the right attorney is a process, right? Take your time. Don't go with just the lowest price, but ask like the right questions, right? Have they ever filed cases for individuals in the same field as you? Have they gotten recent approvals for individuals in the same field, right? Other things that you should also consider when choosing the right attorney is really making sure that they're going to be a thought partner for you, and they're going to be honest with you when they see any flags in your case. No one, regardless of whatever their level of achievements are, has a slam dunk case unless you won like a Grammy or a Nobel Prize, right? So every single time you meet an attorney, they should be able to flag one thing about your case that could be problematic. I would feel a little less convinced that someone is being honest with you if they tell you that everything is perfect. Because for most people who are applying for an EB1, it isn't. The criteria is all over the place sometimes. A lot of like the nuances of the rules adjust very quickly, like we've already talked about memberships, right? So if they're not criticizing you in any form or way, or raising a flag at least one of the prongs, being like, hey, it's possible that the government might feel a different way about this, then I would be a little bit skeptical, right?
The devil is in the details for EB1s. The nuances do matter a lot, and that's what I always push our clients that we work with as well. Is like, hey, don't copy. Use other people's stories or journeys as your reference point, but yours truly needs to be your own, because you don't. While you can see the outwardly appearance of what other people have achieved and what led to their EB1A, you don't know the 10,000 nuances that are underneath that case
Right.
uh, in the process.
Yeah,
Um,
you don't know what kind of funding did that company receive. A lot of the times, like I get a lot of startup founders who are like, "Well, this other startup guy managed to get it," and I'm like, "Yeah, well, you don't know what investors are backing this. You don't know what kind of projects they're actually engaged in, or what kind of partnerships that they have. They just like to say, I'm a startup funder or a founder who just got this company up and going like 6 months ago, and I managed to get an EB1A." Right?
Yep.
What if
Yep.
they're backed by like Y Combinator, right? Like that's like a very different notion than my best friend gave me like $10,000 to start this
The
business.
game flips at that point. Yeah.
Yeah, exactly.
Yeah. Nicole, I know you have to go now, but thank you so much for all your valuable time. This was a very productive conversation, and I know this opened up a segue into a lot more other conversations we can get into. I'd like this to be like the first of several podcasts that we do together in a much more deeper way. But thank you so much for the time today. I'm sure we'll get a lot of questions on top of this, from people who are seeking more clarity into the EB1A, which I'm glad to have had the chance today to solve, at least in whatever small way with you.
No problem. I really appreciated today's conversation, and I hope that you and your viewers are able to get a lot of insight from it. And I'm more than happy to continue having more talks. And maybe we can talk about specific criteria, ideas, and just kind of like what are the current trends right now? Because trends, in my point of view, are everything when it comes to the EB1 and most immigration applications.
Yeah,
So thank you for your time, and excited to work forward in the future in more of these podcasts.
same here. Thank you so much.